I would like to ask Mehak to start the competition.
Sure, ma'am. Respected judges, esteemed opponents, and dear audience, today we are here to discuss on a topic that strikes at the very heart of the system of justice and future of society. That is, should juvenile offenders be tried and sentenced as adults for the commitment of serious offenses? Now, I will demonstrate in the next few minutes that why is it necessary that the juvenile should be treated as adults for the commitment of the serious offenses. Starting it with a quote: justice should not be softened justice should not be softened by the age of the juvenile when it had already hardened the life of the victim. Now, there are few points that why should justice not to be provided as per the age of the juvenile. Number one is the nature and the severity of the crime. The nature of the crime, it determines that what should be the punishment of the juvenile. Crimes such as rape, armed robbery, terrorism, they all require planning, intent, and maturity. And it is all that is required for a person to be convicted under the adults' rules. Number two is accountability and deterrence. As the study conducted in Florida, it shows that when juveniles are tried as per the harsher rules and regulation and provided harsher punishment, then there is reduction in the serious offenses commitment by the juveniles. Next is deterrence. Deterrence basically means the avoidance of repetition of the serious crimes. It is clear that when harsher punishment is provided, it discourage both the individual as well as others from committing the same offense. Point number three is justice for the victims. As we all are aware about the Nirbhaya case, in which there was public backlash when, as per the Juvenile Justice Care and Protection Act 2015, the person are the juvenile who was involved in that rape case, he was treated as per the Juvenile Justice Care and Protection Act 2015. Then the age was altered from 18 to 16 years in that particular case. Point number four, why should juveniles be tried and convicted as adults is legal, moral, and ethical responsibility. Law is no more differentiated from the morality. As juveniles are considered able to understand clearly, they are able to their cognitive abilities are developed, then there should and they are clear and not there is not any ambiguity, so they are responsible for the consequences for the consequences of their action. Next is to address violent juvenile crime rates. We are providing you some data according to the NCRB report, which comes under the Ministry of Home Affairs, that there is an increase of 7% crimes commitment by the juveniles, and as per now 3,40,168 to be correct. These are the number of the offenses they are committed by the juveniles in a nation like India. So it is required to stop these high rates of the crime committed by the juveniles, and which can be controlled by providing them the harsher punishment that comes under the adults rules and regulation. Next, there are certain case and law and legal precedent which also supports the same, as a case from the esteemed US Supreme Court, that is Roper versus Simons, in which the US Supreme Court has also defined that the juveniles who are capable of proper thinking and understanding, they should be treated under the adults rule, but they should not be provided the capital punishment. Even when they are because they have the cognitive responsibility and ability. Mentioning one more case of Eric Smith, where a 13-year-old boy, he has committed a murder of a 4-year-old boy. He was also sentenced as per the adult rules and regulation of punishments, and in that he was given the punishment with the parole permission. Next, the potential of rehabilitation. It is also provided in the adults prison. When someone mentioned that sending the juveniles to the adults prison will lead them to violent environment, they even when they are in juvenile center, they are provided certain facilities. Why can't the certain facilities we can provide them to the adult prison? They can be provided those facilities here.
Mehak, your time has expired.
Okay, so ma'am, now it's the time for the conclusion. Mentioning the conclusion with the case where the five juvenile have escaped from the juvenile rehab center, and they had committed a murder of a juvenile of a jeweler's wife, and also the burglary. So it doesn't mean that providing them rehabilitation will make sure that we will get a safer society. For the protection of the rights of the society, it is required that we should provide them harsher punishment, and they should be treated under the adults rule and regulation. That's all. Thank you, ma'am. Thank you, sir.
Yes, Mara.
Do I have to go for the rebuttal right now or after both of us are done speaking?
No, once both of us have done speaking, then you have to go for a rebuttal round.
Okay, thank you so
Okay,
much.
okay. Now, Mara, your time starts now.
Is today's youngster a born criminal or is he a
Listen,
victim
listen,
of.
Maria. Every
Oh,
participant listen. Before starting, you should tell your team code. Okay?
okay. Sorry, sir. So my team code is
Okay.
TC03.
Okay.
Okay. Thank you, sir.
Okay.
Is today's
Start.
youngster a born criminal or is he a victim of neglect parental? If they had received complete attention, due care, and timely correction, if they were guided with love and affection, would they have become persons of bad intention? Good morning to all the authorities and my worthy opponents. Today I stand before you all to speak against the motion. I believe this topic is of great importance for our community. Juvenile crime isn't conceived in the child, but it is to a great extent present in him as a result of the environmental factors that he is raised in. His silly activities or just absence of order and appropriate training. When the 2015 amendment of the Juvenile Justice Act was being discussed, Congress MP Sashi Tharoor was among those concerned. He said most of the children in conflict with the law were illiterate and came from marginalized families. His argument was, why punish them when the government should be educating them? According to the reports, India has about 35 million children in need of care and protection. Many of these children have no families or can't be safely returned to their families. Traditionally, our nation's juvenile justice system has largely focused on rehabilitating young offenders, helping those who may have problematic home lives or are emotionally troubled. In juvenile detention centers, young people have access to various developmental and mental health programs, including counseling, which is an essential step in making such children better people, which is important for our nation, as the children are the most valuable asset of any country. Apart from this, youth prosecuted in the adult system may witness violence and may be victimized by older inmates, causing long term psychological damage. Another reason it's unfair to try juveniles as adults is that the teens are prone to make irrational, emotion based decisions due to factors like peer pressure, emotional immaturity. Young men and women might engage in increasingly risky behaviors as they go through puberty and test the boundaries the adults have placed on them. The prefrontal cortex, which is responsible for skills like planning and impulse control, is one of the last areas to mature. As a result, as a result, teens may be more willing to do dangerous or illegal things without stopping to consider the consequences. Charging youth as adults ignores the overwhelming evidence. The legal provisions acting upon the same are Section 82 of the Indian Penal Code provides that nothing is an offense that is committed by a child less than 7 years of age. Below the age of 7 years, no newborn child can be blamed for a crime. Section 83 Section 83 provides that an act of a child over 7 and under the age of 12 who has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct. Section 27 of CRPC provides that any individual who at the date of appearing before the court is under 16 years old isn't culpable with death or detainment forever. Well, talking about the Nirbhaya case of 2012, which is the most highlighted one in the juvenile offense. The juvenile culprit in this was sent to a rehabilitation home. After that, a 2017 report outlined what that person is up to now. He is a cook, has a different name, and has supposedly turned over a new leaf. India has seen several landmark judgments that have shaped the juvenile justice system. Here are some of the most significant cases. In the case of Subramaniam Swamy versus Raju through member of Juvenile Justice Board, the issue was whether
Myra, your time is expired.
I just need 15 more seconds. I'm just coming to the conclusion.
Okay.
Okay. The issue was whether juveniles involved in serious crimes should be tried as adults. The judgment was the Supreme Court rejected the plea to treat juveniles involved in serious crimes as adults. In conclusion, trying juveniles as adults fails to recognize the developmental differences, disregards their potential for rehabilitation, and can lead to more harm than good for both the individuals and for the society at large. A juvenile justice system focused on rehabilitation, education, and restorative justice is more effective in promoting long term outcomes for young offenders and public safety. Caught in a cycle, young offenders often need help and not just punishment. Thank you.
Okay, I would like to thank both the participants. Now, you both can go for a rebuttal round, starting with Mehak.
Sure. When we are talking about the deterrence, providing rehabilitation to the young offenders, why don't we mention that these young offenders have worsened someone's life, and the victims, even the society, also needs justice. As mentioning the case of state of Maharashtra versus Vijay Mohan Jadhav, in this case, which is also known as Shakti Mill rape case, in which the adults were punished with death sentence, and the one who was a juvenile, he was not punished with that. He was only sent to the rehab center. So, do you think that providing the one who is approx the age of 16 years, he don't have the ability to understand, he is still a minor? Even when we talk about the Nirbhaya case, in which the age was earlier 18, but it altered the age of JJ Act 2015 to 16 years of age. So there is still development, the age is still decreasing. So don't you think that mentioning the legal precedent what they had done, we are focusing on what they should done, what they need to done. We are here debating that what are the limitations there. And even when we talk about the juvenile committing the motor accident, the Pune Porsche car accident case, we all are aware about that. In that juvenile had committed such accident, and for which he didn't get any severe punishment. Don't you think it will lead the youth that they can commit the offenses prior to the age of 16 or 18, and they will get no more punishment? When you mentioned that the juvenile in the Nirbhaya case, he got a better position in the life, why don't you mention in US the famous case
Keep your
Willie
question very
Basket
short in
case,
the
in
rebuttal
which he
round.
didn't get such
Uh,
he was more committed to the reoffendment.
Mehak, please keep your question
Mehak,
very short.
Sure, sir.
Actually, the question is really lengthy, but whatever I can observe from it, I'm stating that. So first of all, talking about the Shakti Mills gang rape case and the Nirbhaya case. First of all, we are talking about the present landscape of the community, and the Nirbhaya case has occurred in 2012. After which there was an amendment to the Juvenile Justice Act brought in 2015. Okay, and also studies have shown that that the minors, that the Culprits who were minors were sent to rehabilitation home in both the cases, the Nirbhaya as well as the Shakti Mills gang rape case. After the rehabilitation, studies have shown that they have what they are up to now. They are better people. They are leading a good life, a positive life, and they have completely turned the leaf over. So I think the rehabilitation punishments are more useful than deterrence. And also, as this quote says that an eye for an eye makes the whole world blind. So if we keep punishing the juveniles as adults, then I don't think so that they can become better person in the future. And the juveniles, the minors, are the future of any country. So I think the future is in the hands of the people, of the juveniles, and they should be, and the government should work to make them better people and not just to punish them. And also, yes, we do talk about the justice provided to the victim, but also the mens rea of any juvenile is anytime less than the mens rea of any adult. The juveniles are usually instigated or are triggered by the things, by many environmental factors. Usually in rape cases there are pawns that trigger the juveniles. So I do, and whereas in adults there are reasons like the girl was showing off his skin. So don't think so that the mens rea of an adult and the juvenile can be brought to an equation. Thank you.
Okay, now Maria, you can ask the question.
Okay. So, as we are talking about justice and the juvenile system, so the UN Convention on Child Rights, it has clearly stated that the juveniles should be punished on a separate juvenile system, which should work on rehabilitation. And this treaty is in the UN, and India is a member of that. So don't you think that we are breaking this treaty somewhere? We are breaking this convention while not punishing the juveniles while punishing the juveniles as adults. What do you have to say over that?
You are focusing on rehabilitation, which is clearly right. You can focus on that. And even in the adults prison, there is also focus on the rehab. No one is saying that the youths are not going to provide the judgments are not going to provide the youth the rehabilitation. We are just saying that when they commit the severe crime, they should be given the adults punishment, and the maximum punishment in our country is death sentence or the life imprisonment. And we are talking about the serious offenses, not the heinous offenses right now. So in serious offenses, we are providing them the imprisonment of 10 years or more than a 10 years. So here we can also give them a chance of rehabilitation in the adults prison, where you are saying that in the adult prison might they get came to the violent environment. As we can develop the juvenile centers, we can also develop some space for the young or for the youth juvenile offenders in the adult prison as well. So and don't the longer the detention, the longer the rehabilitation will make them a better person. Don't you think? That's all.
Okay,
Actually, my question
now
was
topic
about the
we
UN
have.
Convention on Child Rights, not about the rehabilitation punishments.
It was on
Okay,
child
now we
rights
have
that
the
if
questions.
the child can get rehabilitation.
Participants, please
Now
stop
I
now.
would like to ask the participants to please stop. Now it's time for our judges to ask the question.
Um, First, for the proposition, I have the question, Mahek. Um, how do you ensure that the right of the young offenders are protected in the adult criminal justice system?
So the rights can be ensured by appointing one more jailer in that system that is specially for the youths. And further, their rights can be ensured that at certain places in the adult prison where the juvenile offenders can come in contact with the general prisoners, those places will be secured with more person or officers who will keep an eye on them.
Do you really think is it possible that only one jailer or not allowing the adult prisoner to come in contact? with the young prisoners? Is it really possible? Practically, is it really
We
possible?
can we can increase the number of the officers who will be deployed there, and even when we are talking about their certain meeting points such as the place where they can get food, we can basically make a slight separation between them, and where the person who are of serious offense, who had committed serious offenses and they had come to the prison, we will make sure that the juvenile offenders will be kept apart from them.
We have often seen news that the in the female prisons, the prisoners they got pregnant or they come in contact with the male staff. Uh, so at that time we can see even that is also possible in prison. So how come it will not affect the young prisoners? Rick, do you think it is really possible that they won't come in contact at any time if you treat them as an adult? They will keep them in the same prison.
So, as far as the female prisoners are concerned, we will make sure that more females will be deployed there. And if certain situations are there, we will make sure proper surveillance is there. And also, if such circumstances occur, they should be definitely reported in the courts, and strict actions will be taken on them.
Okay, man.
Thank you, sir.
Maria, I have a question for you.
Yes.
Um, uh, what do you think? To in what extent should the potential for the rehabilitation influence the age of juvenile determination?
Pardon, sir.
What do you think? To what an extent the potential for rehabilitation influence the age of juvenile determination?
Okay. Much obliged for your question, sir. Sir, I feel that there's a lot of scope when there are punishments like rehabilitation done for the juveniles. Sir, rehabilitation counseling, therapies, and which actually work to make a juvenile a minor culprit a better person. So, sir, I feel that. The juvenile minors usually who are in conflict with law are usually in need of care and protection, and so sir, that's why because of their mental mindset, they usually indulge in committing such offenses, and I feel that by providing rehabilitation they will definitely work on becoming a better person in future.
So, to what an I mean, what do you believe that it is a psychological question, I guess, and you see, the brain development of a juvenile. Uh, so, I mean, if you're not lowering the age or not punishing them, and what do you think about the brain development? Is it not the same as we see the technology and everything is growing day by day? So, is it not like the brain is developing very fast, and the first element in a criminal liability is the mens rea. So if the brain of the child has been totally developed, he is fully understanding that what he is doing is right or wrong, then why should you not be treated as an adult?
Okay, so while talking about the brain development, so as I mentioned in my speech also, the prefrontal cortex, which is responsible for for all the skills and planning, which is a part of the brain, sir, that is one of the last areas to mature in a child, and without that, a child usually tend on doing impulsive acts. And sir, while talking about technology, then I think technology is one of the major factors in indulging in influencing a minor to commit such crimes. So, like in most of the rape cases, technologies which is like porn videos or anything like that usually trigger or instigate the child committing such offenses.
Okay, Myra.
Thank you, sir.
Others, sir?
Hello. Yeah,
Yes.
Mehak, I have a question for you.
Yes, sir.
Yeah. What is serious offenses as per you? As per defined in JJ Act, what is serious offenses?
As per the Juvenile Justice Act, there are three type of offences: the petty offences, the serious offences, and the heinous offences. Talking about the serious offences, they are these offences are basically the one which in which the age is not altered right now. Serious offences include such offences that are burglary, and which includes theft, theft not at a small level, but murder are also included, including rapes and terrorism, kidnapping, these type of offenses.
Sorry,
The drug,
Mehak, sorry to interrupt you, but Maria, I would like to request you to open your camera, as if you do not open your camera, it will lead to disqualification.
I'm so sorry, ma'am.
Okay, Mehak. Actually, the serious offences as described in JJ Act, the serious offences are those offences which has punishment from 3 years to 7 years at
yes.
the jail. Okay, at imprisonment. Those are the serious offences, and most of the examples you have given were of heinous offences, like rape and murder does not get in serious offences criteria. Okay,
So for sure, so I will keep in
and
mind.
Maria, have you studied JJ Act for the debate competition? Have you researched about it? Because you have discussed about the child which are in need of care and protection, but as per the JJ Act there are two kinds of child, if you have studied that. Do you know about that?
Yes, sir. So one are
Okay.
in conflict with the law, and one are the other one are in need of care and protection.
Yeah. So the part we are discussing here is about the one who are in conflict with law. So do you think they can be reformed by this? What points you have discussed? Do you think they can be reformed?
Sir, I feel that the children who are usually in conflict with the law are the victims of the are the victims or are such children who are usually in need of care and protection. Sir, as I mentioned in my speech, that there are certain debates about it, that the children who are in conflict with the law come from very marginalized families, or are illiterate, are not given proper education, or are a result of neglect parental. So, sir, I feel that somewhere the child who are in conflict with the law are the same children who are in need of love and care and protection.
Okay. So is there any study about it by UNICEF?
Sir, I'm really sorry, sir. I plead ignorance. I did not research about that.
Okay, fine.
Hello, hello. I'm audible.
Yes, sir, you are audible.
I have same question with both participants. Kindly listen. Have you read general principle as per JJ Act, which are required for the betterment of child laws? General principle. So kindly tell me five principles if you both can remember. Am I clear?
Yes, sir.
Okay. If you can't
So
recall, you can say.
sir, first is the rehabilitation and recovery, which means reintegration. Next, for their right of protection, the interest of the child, by which he can be helped in the juvenile center for his for making the confidentialities, also a point, confidentiality. Next, and one more is the accountability and monitoring.
Okay. Maria,
Sir, I plead ignorance. I cannot remember them right now.
it's okay.
Okay, so judges, are there any questions you want to ask to the participants?
No, we are done with this. Please call the next
Okay,
slot.
okay. Thank you, Maria and Mehak. You can lead the chat.
Thank you.
Okay, so welcome Lisa and Abha. Um, Judges, our first participant is Lisa Gupta with team code 02. Lisa, you can start.
Okay. Imagine a 17 years old who murders someone. Should they get a lighter sentence just because of their age? No. The should decide the punishment, not their age. Good afternoon, honorable judges, worthy opponent, and fellow debaters. I stand before you today to argue in favor of trying and sentencing juvenile offenders as adult for serious crime. The severity of the crime should determine the severity of the punishment, not the age of the offenders. If a juvenile is capable of committing a heinous crime, they should be held accountable for their action, just like an adult. Trying juvenile as adult versus trying juvenile as an adult serves as a deterrent to potential offenders. If they know they will face adult consequences for their action, they will be less likely to engage in criminal behaviors. They will think twice before doing something wrong. For example, if a teenager who knows they will face adult prison time for armed robbery, he will not decide to do it. While age is an important factor, it does not consider the only consideration. The severity of the crime should determine the punishment. Like in the Nirbhaya case in India, one of the predator was a minor. The brutal nature of the crime led to widespread public outrages and call for justice. Many argue that the minor involved should face harsher penalties reflecting the seriousness of the crime. This case illustrates the challenges and the strong emotion involved when dealing with juvenile offenders who commit serious offenses. Allowing juveniles to be tried as adults for served crimes ensures that justice is served and can act as a deterrent against future violent act. It sends a clear message that such served crimes will be met with significant consequences, maintaining fairness and safety in our community. The brain development argument is not a valid excuse for leniency. While it's true that the brain is still developing, this does not absolve juveniles' responsibility for their actions. Just because the brain is still developing does not mean young people can't understand right from wrong. Like the case of Column High School shooter who was 13 to 18 years old, they knew what they did was doing wrong. Moreover, trying juveniles as adult does not mean they are beyond rehabilitation. It acknowledges the gravity of their action while still providing opportunity for reforms within the adult system. This balanced approach ensures accountability while recognizing the potential for change. Rehabilitation alone may not be enough for serious offenders. Incarceration and punishments are necessary to ensure public safety and justice for victims and their families. In conclusion, trying juveniles as adults for serious crimes is essential for justice and public safety. It addresses the severity of the crime with appropriate consequences while still allowing for the possibility of rehabilitation and reform. Trying juveniles as adult acknowledges that some young peoples are capable of making adult decisions and must face adult consequences. It's not being tough on crime, but about being just and fair. Thank you.
Okay, now it's time for Abha Shukla with team code 15.
Good afternoon, judges and my opponent. My team code is 15, and I would like to begin my speech with the lines of Mahatma Gandhi that condemn the sin, not the sinner. Basically, the Mahatma Gandhi's ideology was to focus on the Reformation theory. Likewise, in India also we follow the Reformation theory. Basically, the development of any nation depends on the children of that nation. The better development of the nation basically depends on its children and their basic development. In the development of the nation, we have faced like problems like juvenile delinquency. The juvenile delinquency means charging a person who is involved in a criminal activity who is under the age of 18. uh, we can focus on the reformative theory and the reformation of that child and the development of the mind of that child. Our Constitution of India basically focus on the development features of the children. For example, Article 15, Clause 3, which focuses on the that state can make laws regarding the women and children for their development. Article 39, Clause F, which focuses on the children development and opportunities. Article 47, which guards the state to make laws and provisions regarding the children's education. Our Constitution of India and our judiciary theory basically follows the reformative theory of punishment, which state that we should focus on the rehabilitating the offenders, not punitively or harshly punishing them in so that it can create their mind, it can damage their mental capacity, and we should focus on reformating the offenders. The provisions like the Juvenile Care and Protection of Children's Act 2015, which empathizes the rehabilitating juvenile offenders by taking measures like vocational trainings, sending them to correction centers, and like counseling processes, educations, and it really focused on reformating that child and reforming their mind to create a creative person so that they can also contribute to their nation later. And some more provisions like decreasing the punishment of the offenders uh, if they are of willingness to reform and demonstrate a good behavior in the jails, which is included in the CRPC also under Article 4 under Article 300 under Section 360. And now I would like to share some of the case laws which is related to juvenile justice. For the first case law is Sheila Bare versus Union of India. In this case law, a petition was filed in the Supreme Court in which the Honorable Supreme Court had said the offenders who are less than the age of 16 should be released from the prisoners, and they should be sent to the juvenile courts. Juvenile schools and juvenile homes should be settled up in our country for the reformation of those offenders. And the another case is Pratap Singh versus state of Jharkhand. Uh, in this case, it was said that if in any case it is not entertained in the very beginning that he's a juvenile. The case of the juvenile the fact that he's a juvenile, it is entertained from the beginning of that offense, from the offense is stated, not from the beginning of the proceeding or the magistrate had stated. And these case laws really shows how the Juvenile Protection Act is applicable to India in case of reformative theory. For at last, the factors which are responsible for the factors which are also responsible in these cases are like financial factors, family factors, individual factors, substantive factors which are responsible for juveniles doing the crime. If we focus on these factors and improvement of these factors, this will decrease the crime rates by the juveniles instead of punishing them like an adult. At last, I would end up with some conclusion points, like we can teach the children that if they will do such crime, about the laws regarding it, so that it can make their mind up that they should behave they should behave morally and better to the society. The nationalism proportion in the habits of the children, uh, the
Abha, your
fun.
time is up.
Okay.
5 seconds.
Okay, so as you are
5 7.
aware, you have to go. Divyanshi, please mute your mic. Okay, so as both the participants are aware that you have to go for a rebuttal round. So, firstly, Lisa, you can ask your question.
Okay. In case where the juvenile offenders show a pattern of violence behavior, how should the justice system address that? You are
Abba,
muted.
please unmute yourself.
Like if they are first time offenders, they should be treated through the reformative theory, and they should get a chance to reform in them. And the judiciary really focuses on that. So, and if on the basis of that case, and on the basis of facts and evidences, if the case is too harsh to go to that reformative theory, and if it is not applicable to that case, in those cases we can we can like punish them, but not a very harsh punishment. Like we can separately make prison them, or like we can have provisions which are not related to adults. We cannot have the punishment which is given to an adult and to juvenile. That should not be equal, but we can at least we can teach a lesson through that. But we should really focus on reformating that person. And this should not be given on the first time if anybody commits an offense.
But they are committing the comment. They are committing the comments in a certain pattern only, after again and again after having that punishment also.
Okay, if they are committing that offense in a very series, so they can be teach through correction centers and vocationally trainings, that they should be teach through their moral values. And we should also focus on the psychological and mental capacity of that person. For example, sometimes a person do a series of offenses due to some consequences. Maybe he was treated matlab in abusive family, or he is due to his financial conditions he is committing that offense. We should focus on those factors also, like financial factors, mental capacity of that offender, the psychological problems, and the financial problem. And as an individual also, we should be aware, we should make that person aware of that crime and the consequences which will fall.
Abha,
And
kindly conclude. Your time is up.
okay.
Okay, Abha, now you can ask question to Lisa.
Lisa, for example, a person who has committed an offense for the first time, don't you think that person should get a chance to reform if he is really feeling so guilty about that, and due to any problem he has committed that crime?
That should be decided on depending upon the severity of the crime that he had committed. In case of Nibha case, the minor was involved. He committed a severe crime of getting raped, of raping a girl. That is not something which he doesn't know that it is wrong or it is right. The thing that he is committing, they are aware what they are doing is wrong or right. So according to me, that should be depend on the severity of the crime they committed.
Okay. What if the person is not psychologically fit, or he is mentally disabled to understand the seriousness of the crime? And if don't you think in those cases also he should get the chance to reform?
No, in those cases, they can get the chance by with the full proof that he's psychological, not mentally not stable, or in anything that is involved. But if he is not, he is fit. I think he should get the punishment according to the adult consequences.
Okay, if the person is psychologically fit and mentally fit, but he happens to do that crime due to some influence like social media influence, or due to some influence of his friends and family maybe. So, what about those cases if a person did not confess himself to do that crime? He had done that crime in the influence of somebody else, and like, don't you think he should get that ability to reform again and to
In those
serve the
cases
nation?
also, in those cases, in adult consequences, there are some cases also that involved that people has committed crime by the influence of something of social media or by other any other person. They have punishment for those also. He can get the punishment in adult consequences with respect to that matters also only. Like if an adult committed a crime that in influence of another person, he will get the punishment
Lisa, your
lighter
time
than
is
the.
up.
Okay.
Now I would like to ask the judges if you want to ask questions to our participants.
Okay, these are a question for you as you are for the motion. Uh,
Yes, ma'am.
will lowering the age and labeling the young people as an adult criminal, uh, don't you think it will have a lifelong negative consequences and impact on their life?
So can you speak louder?
Okay, I was saying labeling young people as an adult criminal, don't you think it will have a lifelong negative consequences and impact on their life?
No, sir, I don't think so. Because in adult consequences, if we put them in adult consequences, we'll try to balance out their brain development and the crime they have committed.
Okay, that wasn't the correct answer. Uh, so okay, give me one more answer to a question. That if we reduce the age limit, uh, don't you think that the overcrowded in the adult prison, which will lead to harassed condition and more risk?
Sir, I don't know about this.
Okay, Lisa. Okay, Abha.
Yes, sir.
Okay. You said that the age limit should not be increased and the child should not be treated as an adult for the heinous crime. Uh, if we reduce the age limit and we treat them as an adult, uh, the serious offences and the public safety, it will both be controlled. What do you think about it?
Sir, actually, I did not get the question, sir. Okay, sir, can you repeat the question again?
As we reduce the age limit and uh, the if we reduce the age limit and the adult punishment, don't you think it will deter some young people for committing serious offenses, and also it will be for the safety of the people?
Like, sir, if we reduce the age from 18 to some age down like 16 and 15.
Yes.
Okay, sir. So, sir, in those cases, if the age is reduced, so the basically it is an amendment which is made by the judiciary, and if in case our age is decreased by the judiciary, in those cases, as the law is never static, it is always dynamic in nature, and if the state or the nation really needs to decrease the age limit. So in that case they can do so, and the prisoners who uh, uh, are in already in the crime, or who are if the age is decreased from 18 to 16, so the age from 17 to 18 the prisoners can be released like that, or the proceedings which has already worked with that cannot be performed again, but the proceedings which will be done afterwards, that law can be applied to them.
Um, that was okay, but it was not up to the mark. Um, okay.
uh, Sir,
I'll ask you
I
another
don't
question.
understand
I'll
what your question
ask
exactly.
the question.
Hello. I have same questions with both participants. I'm clear. I'm audible.
Yes, sir, you are audible.
Okay. So you both should tell where the term juvenile is defined, and if you know the answer, you should quote where it is written and what is written. First question is that, and second question is that you both are talking about juvenile and juvenile laws. So 2015 Act, when it was enforced. My questions are clear. If you know answer, you should say. If you don't know, you can say no, sir. You both are talking about juvenile. This. You should know where the term juvenile should be defined. Do you know? Yes or no?
Sir, the Juvenile Care and Protection Act was first influenced in 2000, and it was got amended in
No, listen,
2015.
listen, listen. I'm just asking the Juvenile Act
You should check the
2015
definition
when
clause.
it
Sir, you
was
asked for the
imposed.
definition clause.
What, sir?
आपको
Hello.
जुवेनाइल जस्टिस बताना है किस सेक्शन में कहाँ मेंशन्ड है.
बस बस वही सब मैंने पूछा इनसे कि जुवेनाइल शब्द कहाँ परिभाषित किया गया है। आप एक प्रश्न बता दीजिए, दूसरा प्रश्न आप ये बता दीजिए कि जो 2015 का एक्ट है वो कब इन्फोर्स हुआ। सिंपल सा क्वेश्चन। ओके, इफ यू डोंट नो इट्स ओके।
Okay,
As
Lisa. Yeah, wait a sec,
Yes,
please.
sir.
Yeah,
yes, sir,
Lisa.
you
Actually,
can.
I have a question. The topic was about serious offences under JJ Act, right?
Yes,
So
sir.
you do know what is serious offences under JJ Act?
Like committing murder, crime, robbery,
Okay.
rape.
Have you checked it?
Yes, sir.
Okay, then you checked wrong. It's fine. Okay, Abha,
Yes, sir.
what are the reforms? What are the reforms strategies are provided by UNICEF? Do you know what is UNICEF?
Yes, sir.
Okay, what are the reform strategies are provided by the UNICEF for the betterment of children against in the conflict against law?
Sir, like sir, like correction centers, rehabilitation process, and sir, restoring
Are they provided
process.
by UNICEF or provided by JJ Act? Both are a
Sir,
bit different, right?
yes, sir, both are different.
Acha, in JJ Act 2015, how children are categorized under the Act? There are two types of children, right? Any of you can answer it. Like
I would
children in,
like
yeah.
I would like to request the participants that if you know the answer, please reply to our judges. And if you don't know the answer, please say no because you have a particular time limit.
So sorry, sir. I don't know about the two types of children. Sorry.
Sir, I also don't know about.
Okay. After this session, research about the serious offenses and difference between serious offenses and heinous offenses, and what are the category of child defined in JJ Act. Okay.
Yes, sir.
Okay, sir.
Always keep one thing in mind that before moving to a conceptual question, you should first read of the act. You should be aware about at least aware about the act, which what section, what is basic principle, where the points have been mentioned. A conceptual
Okay, sir.
question you can answer it, but it is important for you to have this all the answer to the question regarding the act which has been asked by all the other judges. You are not aware about the definition clause or the basic questions. So no, you can move to conceptual answers, but it is very important of you to go through whole of the act. Okay,
Yes, sir.
team, call the next lot.
Thank you, sir.
Okay, thank you, Abha and Liza. You can leave the chat.
Thank you, sir.
Mansi, I would, okay, good. Mansi, you have to open your camera during the entire.
Mic मेरा my Bluetooth disconnected. Am I audible?
Yes, you are audible and you have to open your camera.
Okay, okay.
Okay.
Yes.
So, judges, we have Anshika Srivastava with team code 20 and Mansi Gupta with team code 28. So, we will proceed with Anshika Srivastava, team code 20.
Good afternoon to one and all present over here. Myself, Anshika Shrivastava, and I will be speaking on the topic should juvenile offenders be tried and sentenced as adult for serious crimes? And I will be speaking for the motion. So, I would like to start by clarifying the definition of a juvenile. A juvenile is a person who is below the age of 18 years and have committed a crime. According to Juvenile Justice Act, there are two categories of children. First, children conflict with law, and second, children who are in need and protection. There have been increase in the number of crimes committed by juveniles. You must have heard on social media that a minor is raping someone or killing someone. It does not put a question only on the judicial system, but also on the whole society because the children are the building blocks of the country's future development. The government should invest more on adolescent children and these teenagers. Also, juvenile is a grim reality, and the scariest part is that there have been increase in the number of serious crimes committed by juveniles. But for these crimes, they are just sent to juvenile homes or correctional homes without giving any proper punishment or serious punishment. The purpose of sending them to juvenile courts is a incursion of good habits, rehabilitation only. So, uh, but this trend is rising, and there should be more punishment given to them because it is not clear that after serving the juvenile home, they would not commit a crime. As per various experts, the current laws are not sufficient to deal with this problem, and they should be tightened. You must have know the Nirbhaya case where 6 out of 1 member was a juvenile. He was 17 years of age and he was released after a certain period of time with a new identity. So my question is that is it enough? Is this justice? Also, in the Posh case, the minor was just being released after writing an essay. So, the is this justice? Is the life of a person just worthy of just a single piece of essay? Also, there was a case where an 11th class student killed a 8-year-old girl from the same school because on that day he had an exam and he wasn't prepared for the exam. So, to declare a holiday, he just killed a child. It was just a mere act because these juveniles aren't scared of punishment. They just done it because they know that they are minor, and if they commit the crime, they will just be released after that. So, uh, also there was a case in India where Amarjit Sada, he was the youngest psychopath who had killed his sister, his brother, and also a neighbor girl. He was just 18 years of age when he took three lives. And he's just his psychologist told that he was a sadist, that he get pleasure while hurting someone. Now, is the punishment given to them by sending him to the juvenile board or the correctional home is enough? Shouldn't he be treated as an adult for this for three murders? So the government, our judicial system and the government should make more tightened laws or the stricter punishment so that these juveniles should be more we can say that more scared of the punishment given to them. In conclusion, I would like to say that increase in the crime rates is major concern for the whole society and the judiciary system. There is a need for stricter laws. The OTT platforms, movies and web series should be restricted. Also, there is increase where the children are addicted to pornography, which have increased the rates of uh, crimes against women like rape, gang rape, or murder, assaulting, and stalking. These should be addressed by the concerned authority seriously. Crime is a crime, irrespective of age. The criminal should be punished without any discrimination to set an example for the society, and the society must be freed from these criminals. Can the juvenile board or the judiciary give us guarantee that after being serving in juvenile home, these criminals won't do the crime again? Is it they provide safety to our society? So I hope the concerned authorities and the judiciary would look seriously into the matter and would provide better future to these younger children. Thank you.
Thank you, Anshika. Now, Mansi, you can proceed.
Rehabilitation happens when the teenagers are forced to connect their communities and confront their mistakes. Hello everyone, I'm here to speak against the motion. Minors as young as 14 can be tried as adults at judge discretion. However, mounting evidence suggesting this approach is harmful and ineffective. What are the adverse effects of trying juvenile at adults? Traditionally, our nation's juvenile justice system has largely focused on rehabilitating offenders and helping those who have problematic home lives or emotionally troubled. In juvenile detention centers, young people have access to various developmental and mental health programs, including counseling to help with issues like substance abuse. In contrast, the criminal justice system is primarily punitive, offering few educational or rehabilitative services for the inmates. Youth prosecuted in the adult system may witness violence and may be victimized by the older inmates. causing long-term psychological damage. Additionally, criminal records resulting from adult conviction can limit a young person's future education and career opportunities, while imprisonment intends to deter people from the committing future crimes. Treating juveniles as adults has opposite effects. According to the Office of Juvenile Justice, Delinquency and Prevention, over 9,600 children are jailed in adult prisons between January 2016 and December 2021. There are developmental difference between juveniles and adults. They both are different things. Another reason it's unfair juvenile adult as adults, the teens are prone to make irrational emotional based decisions due to the factors like peer pressure, emotional immaturity. Young men and women engage increasingly risky behaviors as they go through puberty and as boundaries adults have placed on them. True children's brain are nearly fully grown by age 7. That does not mean it's developing. The prefrontal cortex, which is responsible for the planning and impulse, one of the last areas to mature. As a result, teen may be more willing to dangerous or illegal things without stopping to consider the consequences. Charging youth as adult ignores the evidence. Increasingly, youth affects the whole complexities in the juvenile justice system, and court may make to confuse powerless, which can cause emotional upheaval in family. In addition, while financial hardship is a risk factor for a crime, the economic burdens associated with fees can have long-lasting financial consequences. To avoid these ramifications, must hire an experienced juvenile attorney to help your family and ensure a brighter future for your child. Now, I would like to conclude it. Youth in the juvenile justice system have facilities, they are being utilized for the treatment and rehabilitation. However, many youths are subjected to abuse, unlawful, and inhumane conditions of confinement. Detained, committed, youth in need of education, treatment, and healthcare. Legal counsel have the right to be protected from the violence, unsanitary, educate, access to counsel. Shows that subjective due to such harsh confinement conditions increase rate of violence and recidivism in society. Cases already faces daily violence and crime. Efficiency and care of only further threaten and well-being of our children, families, and communities. It is not guaranteed that after all treatment like adult, he will not become a criminal. Many of criminals become more dangerous because they are knowing which kind of life they will live after they, and they are habitual of that. They have no fear of jail. Then I would like to say, you can listen a man, but can't change his mindset without helping and giving them a chance to themselves. It can only change with the help of proper education, love, and psychological help. Thank you.
Okay, thank you to the participants. Before proceeding for the rebuttal round, I would like to inform both the participants that you have only permission to ask one question at a time. And the second thing is, please make sure that your question is short and not lengthy, as it will take time. Okay, starting with Anshika, you can proceed with your question.
So I would like to ask, if juvenile does not held accountable such as adults, doesn't it send a message that they can commit the same crime again with impunity, assuming that they would be released for the good behavior again from the juvenile board? Doesn't it put public safety at risk?
As I said, plus it is not a guarantee that after the treatment that adult will not become a criminal. Many of criminals have just because they are knowing which kind of life they will live after they will do any crime. They have no fear of jails. Then you can listen a man, but you cannot change his mindset without helping them and giving them a chance to improve. It can only change with proper education, love, and psychological help. Is my answer clear to you?
But in adult but in adult criminal system, the jail is for 7 years or death penalty or sentence to life to imprisonment. But for juveniles, it is only up to 3 years, whether they commit murder or crime. Is it not possible that they will commit the same crime again after being releasing from the juvenile board, after even after giving proper treatment?
Do you know how many types of juvenile crimes are there?
Yes,
Like, please recall it.
murder, rape, rioting, vandalizing.
No, no. I'm asking about the types of juvenile crimes.
Three types: children below 16 year of age, children between 16 to 18.
That only 3 years of jail can be given to the juveniles, but there are three types of juveniles: petty offenses, serious offenses, and heinous offenses. Petty offenses are given.
So the topic is for serious crimes only. You don't know the title?
Serious crimes are given 3 to 7 years of jail, and heinous
No, not
are 7 years of jail.
not for juveniles.
Mansi, your time is up.
Both the participants, you have to remember that question has to be asked on the subject you have been allotted, and not the question here not should be uh, related, मतलब it should be related to the to what you both of us said. नॉट आपको आंसर नहीं करना है, मतलब एक दूसरे को क्वेश्चन इसलिए नहीं पूछना है कि आप कोई क्वेश्चन पूछ रहे हो. रिबिटल में क्या होता है कि यू हैव टू अंडरस्टैंड व्हाट इज रिबिटल हियर. रिबिटल इज फॉर द पर्पस दैट वी आर काउंटरिंग द क्वेश्चन और द स्टेटमेंट विच वन पार्टी हैज मेड. आपको यहाँ पे क्वेश्चन नहीं करना है कि आपको इसका ये क्वेश्चन का आंसर बताओ तो इस क्वेश्चन का, ये सब नहीं है इसमें. आप अगर उसके किसी स्टेटमेंट से सहमत नहीं है, then you have to ask कि why have you mentioned this या tell me about this thing. ये आपको पूछना है. आप समझिए क्वेश्चन कैसा होना चाहिए.
More dangerous. They are knowing which kind of life they have to live. I have answered her question.
Both of you have used their rebuttal.
Yes, sir.
Mansi, now you can ask your question, but remember you have only chance to ask a single question, not more than that.
Okay. I would like to ask her what is the best program given at Edward?
Sorry, you are not audible.
I would like to ask what is the best program for juvenile delinquents? What are the programs according
Sorry, can you repeat? You are
Mansi,
not audible.
program of juvenile delinquency? What are the effective programs for that?
Sorry, you are not
Very
audible.
audible, not audible, Mansi.
Um,
Mansi, I would like to inform you that there is a breakdown in your voice, so please check it once as you're not audible completely.
I'm audible.
Mansi can write. If you can write it, write the question. You can write the
Yeah,
Please
question.
write the question.
Mansi, you're not audible at all.
Hello. I'm
Hello. Mansi, I think there's a problem in your network. You can write your question in the
Am I
message.
audible now? Am I audible now?
Yes, you are audible.
Yes.
Yes, I'm asking her what is the best prevention program for juvenile delinquency? What are the effective programs for that?
Essential programs for juveniles.
Yes.
They can be given care or protection inside the juvenile board. I'm not saying that every juvenile should be sentenced as adult, but I'm saying that juveniles that do serious crimes like rape or murder, that are sadists or psychopaths, should be tried as adults. And the juveniles that do the crimes by manipulation or under peer pressure should be taken to the juvenile board and should be given proper care or attention and education before being releasing from there.
But I am asking you the effective programs. And I already told
Counseling.
you that I already told you that there are development differences between juvenile and adults.
Yes.
And I already told you that there are development differences between juvenile and adults. If the juveniles will be treated as adult, then they can be how should I say?
A
Okay,
16 or
time is for the
17-year
debating round.
old
Time has
is
passed.
mature enough to understand the consequences of their actions.
No, the prefrontal cortex,
I
which is
would like to stop both the
responsible for the real
participants.
time.
Mansi and Anshika, please stop
Okay,
because you both are violating the rules. As a teacher is saying something, you both should stop and listen to what he is saying.
sorry, he was not audible.
Sorry, ma'am.
Sorry, he was not audible. Yes,
Sir,
sir.
do you want to say something?
Okay, the time has been up for the debating round.
Okay, sir.
Okay.
Yes,
Thank
sir.
you.
Now it's time for teachers to ask the question.
Hello. I have
Yes,
question to both participants. Uh, if a juvenile who is in conflict with law, okay, is in apprehension of police officer, then what is the procedure? Is he should be jailed, or what is the procedure prescribed in JJ Act?
Sir,
If
please
some
repeat
police
the question.
if some police officer booked a child, a juvenile who is in conflict with law, then what is the next step?
sir. He should be uh, should be tried if he has committed a serious crime or heinous crime, which kind of crime he has committed. Then he can be that uh,
Sir, can you please repeat the question? I have not listened.
he can be tried. That
I'm
he
audible.
Yes, sir.
I'm asking that if a juvenile is in conflict with law, then if he is booked by a police officer, then to whom he is to be surrendered? Like he should be jailed or not?
sure no sir. First he should be tried as adult. He should be tried that he has committed a serious crime or heinous crime or which
Listen, this is the express provision. This is the express provision under a section in the JJ Act. If you know, you should answer that. Or you can say that, no, sir. I'm asking to whom he is to be surrendered, either in jail or to someone authority. Who is the authority to whom the police officer will submit the child?
Sir, to Juvenile Justice Board.
No. Before that, there was a mediator. Who is that mediator? A police officer cannot submit directly to the Juvenile Justice Board.
Sir, an advocate.
no.
No. There is a express provision in section 10. The police officer will submit the child to special juvenile police unit or child welfare police officer, and they will submit the child to board. Okay.
Okay sir. Thank you sir.
Oh, thank you.
Hello.
Yes sir.
Yes, sir.
Yeah, Anshika. Actually, while I was listening to you, you were discussing about some data provided by some experts. Can you name the expert or provide some detail about that data? Where you get that from?
Sir,
Am I audible?
yes, sir.
Okay.
Sir, the name of experts was not written specifically.
So you shouldn't quote them, na, if you don't have the name of them, right? Okay, second thing, what give an example of a serious crime as per JJ Act.
Sir, in Nirbhaya case, the juvenile who was 17 years 6 months old was not hanged, and instead he was sent to juvenile board, and
Yeah,
he was
actually,
being released. And
yeah,
sir,
Anshika, I was not asking about case. I was asking about a provision or any offense which can be categorized as serious crime under JJ Act. Can you describe the serious crime as per JJ Act? Can you define it?
sir, rape, murder, gang rape,
Those are
rioting.
examples, and none of them are of serious crime. They are heinous crime as per JJ Act.
Sir, can I?
Yeah, I know you know. You have asked that question. That's why.
Yes, sir.
Okay. Do you know Anshika?
Yes, sir.
Do you know about what is serious offense? Do you know that as per JJ Act?
Sorry, sir, I don't know.
Okay. Basically, it was the topic of the debate, so you should basically research that. And Mansi, you have done very good research, I think, but yeah, you are not able to structure your debate. You're what are you saying? You're not structuring that. Okay. Do you have any that you're discussing about reformation procedure? So, do you have any reformation technique provided by UNICEF or JJ Act?
Uh, sir, Sir, there can be principle of presumption of innocence, presumption of dignity and worth, principle of best interest, principles of family responsibility, principle of safety, like that.
Okay, where are these provided?
Sir, in Article 39F and Article 45.
Okay, Article 45 of what?
Sir, of securing childhood and youth against exploitation and ensuring free and compulsory education for
Okay,
children until they
but
are.
have you gone through about the principles of UNICEF?
Sir, I don't know that.
Okay. Okay, then research it about after this session. Okay,
Yes, sir. Thank you, sir.
thank you.
Should we leave?
Uh, Vanessa, do you want to ask any question to the participants? Mansi, you are not allowed to switch off your video during the entire
Sir, my,
call.
actually, my camera is a little.
I'm
My,
okay with
my network problem is there. My network problem is there. I'm not switching off now.
it.
Okay, thank you, participants. You can leave the call.
Okay.
Thank you, ma'am.
Okay, good. So, before proceeding, I would like to inform both the participants that during the entire call, you are not allowed to switch off your camera even for once. So, before proceeding, sir, judges, I would like to inform you that we have with us Soumya Singh with team code 04 and Monica Khainat with team code 10. So, starting with you, Soumya, you can proceed.
So, first of all, good afternoon, everyone. I'm Soumya Singh, and juvenile in India is a person who is considered a child who is immature and lastly bound to make mistakes, whereas an adult in India is a person who is above than 18 years of age. In India, punishing someone for the serious crimes, even their measuring unit of the punishment is his age, no matter how much brutal or serious the crime they have committed. If the same crime committed by a juvenile, he is being only sent to juvenile justice, and when the same crime it is committed by an adult, he is sent to whole life prison, or being sent to death sentence. A juvenile is expected to get some reforms by sending him to juvenile justice homes. But what about the victim? Do we really even think about it? It is really a pitfall of our justice system that if a juvenile will commit the crime, he will be only given punishment of 3 years maximum. But same goes with the victim. If victim is being raped or murdered, he does not get the justice. Let me give you an example. The Nirbhaya case of 2012, in which there were six culprits and three of them were death sentenced and one of them was a juvenile, and he was being given 3 years of punishment only in juvenile justice home, and in the last when he was released he was given 10,000 rupees to lead his life. Isn't it giving a good motivation to commit a crime and go for whatever you want to do as a juvenile? And the court will not punish you. It will only give punishment of 3 years, and in the end, it will also help you to lead your life. If for protecting child's right act, we may consider that he is not mentally developed. But do you really think that a person who commits rape or murder, he does not put a thought into it before committing it? No, it is not really true, and it will be so illogical to even think it. A person who commits rape or murder, he do really have seen somewhere that it is a crime or it is wrong. We are very modern and this age we get to know about right and wrong at very early, at the very beginning, from like social media and anywhere. So juvenile is really getting safeguard from our legal system, which is we are really shameful of it. Juvenile only gets punishment of 3 years and he gets free after 3 years, no matter if he got a reform or if he didn't. And many experts say that if a child drops something, he's not violating right of someone. But if he really commits offenses like rape or murder, he's violating right of someone else. And he better knows it. But what the justice system does is uh, it does not give the punishment as it gives to adults. If the same adult does a punishment, he is being given punishment of whole life. But if a juvenile does the same thing, he is being only given punishment of 3 years. Is it giving a good example to a society, good motivation to it? From the report of 2018, I've got to know that the juvenile offenses have increased to 33%. Isn't really it a big number? Yeah, it is. But let me give you an example. In the district of Shiwan, Bihar, two boys of one of 11 years and another of 10 years, they both raped a girl of 5 year old. Is it really not brutal? What do you consider it? It is really brutal. And don't you think that he did not put a thought into it before committing it? They would have. They would have thought. They are able to get that it is wrong, but they still do the same thing
Soumya, your
because they
time is
know.
up.
Okay, thank
Your
you.
time is up. Okay, now Monica, you can proceed.
Thank you so much. Good afternoon, everyone. My team code is 10, and I am going against the motion. Should juvenile be tried and sentenced just like adults for serious crimes? So here I start. To begin with, I would like to quote the words of Robert Hindley. That is, there was never a juvenile delinquent. There can never be a juvenile delinquent. Behind every juvenile delinquent or and of a juvenile offender, there is an adult delinquent who is in its mature his or her mature years, and who either does not know their duty or they just fail them. If a child hurts anyone, it's because he is suffering from something. It is there his suffering that is spilling over. We have the juvenile laws to protect them, to give them a framework, a structural framework, so that these troubled kids can get reformed and come as a mature citizens. But why do we need the juvenile laws? Why can't we just treat them as an adults? There are two reasons for this. First, the constitutional provisions and the international conventions, treaties we have signed as a nation. And second, based on the moral grounds. So first, based on the constitutional provisions, we have seen in many judgments on many times the four debaters are always claiming that 16 to 18 years juveniles must be punished just or treated like adults, but it is a violation of Article 14 for them as per the Constitution. And second is Article 15, clause clause 3, which says that no one can prevent a state from making certain laws for women and children. Third is Article 39F, which talks about giving chances to students, to children, and to protect them from material and moral abandonment. We have conventions, treaties signed, like UN Convention for the Rights of Child 1989, UN Standard Millennium Rules for for adjudication of juvenile justice 1985, and also we have the Hague Convention 1993. Based on these three conventions and treaties, we have our nation has formed a juvenile law, which was earlier known as Juvenile Act 1986. Then it was reformed, amended in in 2000, and then it again amended in 2015. And here we have the juvenile laws. And as per the Beijing rules, which we known as a UN Convention Standard Millennium Rules 1985, it is the aim of juvenile justice is given in the section in the Article 5 of the Beijing rules, and it is said clearly that the aim of juvenile justice is to prevent to be for the welfare of the juvenile, and their punishment should be decided based on the circumstances of the offense and the offenders. We have the moral grounds here. The first one is the lack of maturity. They literally, why do we provide them a preferential treatment? The preferential treatment is given to them because of two things. First is doctrine of dolly incapax, means they are incapable of doing wrong. And second is MACR. MACR is minimum age of criminal responsibility, which is the age under which no one is deemed to be committed. No one is can be deemed to be committed a crime. In India, MACR is 12 years as per IPC, and we have a dolly incapax for that is 7 years. And a criminal intent that is of an adult can never be of that level of the child. Second reason is the future consequences. These juveniles, once they will be tried as adults, they can get post post they can they will find it difficult to reintegrate with the society. The third ground is their vulnerability. They are at a high risk to get manipulated. Prisons are the most influential breeding grounds for criminals, for juveniles to get manipulated in the future. These children always ask us in 100 ways that, do you know me? Can you hear me? Can you see me? And it's our as a society responses to them, which is actually reflected in their behavior. We have seen there is a famous quote over this, that a child's life is like a page, and everyone can have a remark over it.
Monica, your time is up.
At last, I would like to end up what I'm saying, that light always thinks it travels faster than everything, but as long as it reaches there, it always finds that darkness was there first and waiting for it. There is another saying that it needs an entire village to raise a child, and we, as a part of that entire village, if we neglect a child, we are depriving him from that light. So let's become the light that can cast away the darkness. Thank you so much.
Okay, thank you, Monica. Now, you both have to go for the rebuttal round, but before proceeding, I would like to inform both the participants that you have only permission to ask one question, not more than that, and your question should be in a very precise, in a very short manner, not in a lengthy manner. Okay, Soumya, you can proceed with your question.
As you mentioned that rights are violated of children, but what about the victim's right? His rights have already been violated. What do you want to say about it?
I agree that the rights of the victims are violated, but that does not mean that we can neglect the right of the accused also. This is the problem of the society. We as a society are failing both the accused and the victim. I know victim's right must be preferred here, but still the accused, maybe there are many reasons that he has that his rights, sorry, he has done things. There can be many causes behind it, and as I already mentioned, that the intent is the most critical element while determining a crime, and an intent of a child can never be the same or at that same level that can be of an adult. So I can say that literally, in my opinion, that literally the rights of the victim is violated, but somewhere the rights of the accused has been violated by from our part also.
I want to say something. Am I allowed to? I want to say something.
Yeah,
Am I allowed?
yes, yeah, you can say.
Okay. Until and unless we do not set an example for the society that doing wrong is wrong, even if it is for juvenile, the young offenders, will not be scared and they will keep on committing the serious crimes like rape and murders. That's it.
Okay, thank you, Soumya. Now, Monica, you can proceed.
I'm referring, I want to ask you that what is your take upon when a child who has done a serious crime is actually influenced by the environment, the surroundings he has been through, means the abuse he has seen in his childhood or whatever. The mentality is set by his surroundings, and it is not actually his own mentality. So what's your take on this, that if he commits the crime, what punishment he should get?
See, here I'm talking about serious crimes. Don't you think that murder and rapes are committed without putting a thought into it? It is not really, and he is um, being given some freedom that he is a juvenile and he can commit whatever he wants. It will not be considered as an offense. He will be only given 3 years of punishment. Committing murder and rape is also a crime for juvenile also.
Okay, thank you, participants. Now it's time for judge to ask the question.
So my first question is with both participants. Same, very simple question. Am I audible?
Yes, sir,
Yes,
you
sir.
are audible.
Yes, sir.
So who is juvenile and where it is written? Who is juvenile?
A juvenile is someone who is below the age of 18 years. It is mentioned in Juvenile Justice Act.
Okay. Where? Where in act? If you don't know, you can say I can't recall.
I cannot recall. Sorry.
Okay, 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 okay. Under definition clause 2, subclause
Sir,
35.
may I answer?
Okay.
Yes, Monica, you can answer.
Okay. Definition clause 2, subclause 35 defines juvenile. Okay. And second question is that is
Some
disclosing
sorry,
identity
sir.
of child. Hello.
Sorry to interrupt you, sir, but I think Monica wants to give the answer of the earlier question.
Okay, okay, Monica. Give an answer if you know anything.
Sir, juvenile is a person who is below the age of 18 years, and he is alleged or found to be involved in commission of a crime uh, or offense as per the IPC or the prevailing laws in India, criminal laws in India, and it is mentioned under Section 2, Subsection 35 of the Juvenile Justice Act 2015.
Okay, okay, thank you. Next question. Kindly listen. Is disclosing identity of children, either he is victim or witness, or a child with conflict with law, or he is
Sir,
child
you're not
in need
quite
and care and protection.
audible.
Hello, am I audible?
No, sir.
So you are audible.
Yes, sir, you are audible.
Monica, kindly check your internet. Okay, I'm audible to everyone. So I'm asking that what if someone disclose the identity of a children? Whatever the character of children is immaterial, either he is a victim, witness, or child in conflict with law or in need and care protection. What if someone disclose the identity of the child? Is it an offense? If yes, where it is written and what the punishment prescribed? So may I start?
So, as you said that revealing identity of the child is a crime. No, I don't think it is a crime because I have got to know the name of the victim, the offender who is involved in Nirbhaya case. He was also a juvenile. So, if it was a crime, it would not have been revealed.
Okay, I will answer. I will answer. Monica.
Sir, I think Monica just left the chat because
Okay,
of
okay.
the
I
technicals.
am giving the answer to Soumya. Section 74 of JJ Act. Okay, prescribes it. Disclosing the identity of a children is a punishable offense, and there is a punishment too. I think 6 months imprisonment and 2 lakh rupees. You can refer it. Okay, thank you.
Okay, sir. Thank you.
Hello, hello, am I audible?
Yes, sir, you are
Yes.
audible.
Okay, yes, Soumya, you said that while you in your speech you said that we are shameful of our legal system that offenders are getting released after 3 years of punishment, right? For
Yes, sir.
crimes like rape and murder. Do you still agree with that statement?
Yes, I do agree.
Okay. Have you studied JJ Act 2015?
I have a little idea about it.
I think you don't because after 2013 Nirbhaya case, there were basically different there are many changes were adopted in JJ Act. One of them were if an offender who is a juvenile has committed an offense which is categorized as heinous offense. Heinous offense are like those offenses which basically like murder, rape, or any other offenses which in IPC is equivalent to punishment for more than 7 years are treated as adults in the eye of law. Okay, but the topic was about serious offenses. Do you know what is serious offenses under JJ Act?
Yes, serious offenses are like murder and rapes.
That's what I'm saying. You don't know that. You should research something before coming to a debate, right? Firstly,
Okay.
research what is serious offense under JJ Act. The offenses you were discussing about are heinous offenses under JJ Act. Okay,
Sir,
and for
Okay.
that, the child are treated as adult in the eye of law. Okay.
So why the culprit was only given 3 years of punishment? If it was
Yeah, because this change was adopted after Nirbhaya case in 2015. That why JJ Act is 2015, right? And the judgment was 2013.
Okay,
Okay.
thank you, sir.
Yeah.
Arun sir, as we have our next participant, Monica, here also, you can ask to her also if you want to ask any question.
Yeah, Monica. Actually, in your speech, you have discussed various things about juvenile cases and all. What are the source of your data? Like you have discussed about research reports, but you never take their name or discuss about the source you're getting your data from.
Sir, basically, I have got the data from the internet only, but there are some cases where we can see it prevailing as well. And like I would like to mention a case. There is
Yeah,
Jarnail Singh
please.
versus. Yes, sir.
Yeah, please mention them.
So Jarnail Singh versus state of UP, the state of UP, sorry, state of Haryana, 2013. I guess the year is 2013. In that case, there was a child who was made accused of taking a prosecutrix from his father's home, and he was convicted and given a punishment for, I guess, around 10 years. Around 10 years. So later on, High Court gave the orders again to revise the case, and in that they have found that that the child was sorry, that the person who was the accused, he was a minor, and the girl has self gone with him with her own consent, and he was just made a scapegoat there.
Okay. And that, look, when you take a data from internet, you should always write the name of websites, as if you someone asks about the source of data, you should be able to answer them. Okay, for next time.
Okay, sir. Thank you so much, sir.
Sir, I want to say something.
Yeah, sure.
Sir, as you have mentioned that the punishment was extended to 7 years, but I really think that it should not be extended to 7 or 10 years. It should be extended to like that punishment.
Soumya,
So
look,
may I
firstly,
answer?
wait a sec. Soumya, firstly, research properly. Okay, I did not said that the punishment was extended to 7 years. The offenses you are discussing about are heinous offenses as per JJ Act, and the topic which we are here to discuss are about serious offenses. And rape and murder are not considered serious offenses; they are considered heinous offenses as per JJ Act. You should research that first. Okay, first study that.
Okay, sir.
Okay.
Vanessa, do you want to ask any question to the participants?
Yes, I have. I wanted to ask the participant Soumya that the juvenile justice system emphasizes rehabilitation. आप समझ रहे हो? Rehabilitation focus करता है और punishment
Vanessa,
नहीं
I'm
देता
sorry to interrupt you. Sir, sir,
है. हाँ हाँ.
sir, I'm sorry to interrupt you, but there's a bit lot of background noises coming from your audio.
Okay, listen carefully. Am I audible now?
Yes, sir, you are audible now.
Okay. The juvenile justice system focuses on rehabilitation somehow, ठीक है, rather than punishment. So if we lower the age or we treat the child as an adult, so would it not compromise the basic theory of reformative theory?
So, basic reformative theory, I do know that, but we should really set an example for the society, for the juveniles, that if they commit a heinous crime, their punishment should be extended, and the age of being an adult is to be lower down.
Okay. Monica, Monica, tell me one thing that reducing the age limit of certain serious offences would enhance public safety. So why is it not in your speech that we should reduce the age so that there be more public safety? As we see that the crime where below 16 or below 18 is more.
Sir, may you repeat the question? I'm quite not audible. It's not.
Reducing the age limit of certain serious offences would enhance public safety. So why is it not? Why the government should not or the court should not lower the age?
Sir, there have been various psychological behavioral researches, which itself which itself gives that the psychoanalytical mindset of a child or of a person is not properly developed till the age of 20 years or till the age of 18, as per we have seen in this era as well, that there is a growing maturity, a mental maturity, but still there are many people who have not that much surroundings, not that much resources that can set that can already set the platform for them to get mature properly. So I think in my opinion that is the only reason that the age is not getting lowered.
In some cases, we see that the rehabilitation program is not successful and harsh punishment is necessary.
Sir, your mic is muted. Okay, thank you, participants. You can leave the meeting.
Thank you, judges.
Judges, I would like to inform you that it is our last slot, and in this last slot, we have only one participant. So there can be no rebuttal round. So you can ask any as much as question you want. Participants, Shashank Tiwari with the team code 32 is present. Shashank, you can start.
मेरी आवाज क्लियर हो रही है उधर?
हाँ, clear है आपकी आवाज.
मैं वाड़ी का राजदूत हूँ, सच पर मरने वाला हूँ, डाकू को डाकू कहने की हिम्मत करने वाला हूँ. उसका मर जाना अच्छा है जो खुददार नहीं, मानवता पर उंगली उठे और मैं ना बोलूं, ऐसा मैं गद्दार नहीं. विद्वता के मानदंड नील छिड़विवेकीय निर्णायक महानुभाव, मेरे देश के भावी कर्णधार भाइयों एवं बहनों, सर्वप्रथम मैं लॉलिसियस की टीम को धन्यवाद देना चाहूंगा जिन्होंने इतने असमचीय विषय को सदन के पटल पर रखा. श्रीमान, विषय के विपक्ष में बोलते हुए मुझे गर्व की अनुभूति हो रही है कि मैं मानवता का पक्ष रखने के लिए प्रस्तुत किया गया हूं. मान्यवर, विषय की गूढ़ता को स्पष्ट करने के लिए मैं 3 प्रकार के पक्ष प्रस्तुत करूंगा. पहला साहित्यिक, दूसरा ऐतिहासिक और तीसरा संवैधानिक. भारतीय सभ्यता और संस्कृति की आधारशिला अर्थात साहित्यिक पक्ष में देखें तो कबीर कहते हैं, यौवन ज्यों का होतना जैसे बचपन जात समय समय बदलत रहे मीकी जैसे रात। अर्थात बचपन का संबंध हम यौवन से नहीं कर सकते, क्योंकि वाल्मीकि के रामायण की गाथा आज घर घर गाई जाती है, जो बचपन में अंगुलीमाल डाकू हुआ करते थे। अगर मैं ऐतिहासिक पक्ष की बात करूं तो रामिन्स और कार्डनेट की परिभाषा तथा महान अर्थशास्त्री एमजे स्टेलन की कृति सोसाइटी एंड क्रिमिनल में स्पष्ट रूप से कहा गया है कि बालक के आपराधिक चरित्र के विकास में जो तथ्य जिम्मेदार हैं वह हैं भौतिक वंशानुक्रमण, आपराधिक भाई बहन, माता पिता द्वारा तिरस्कार, परिवार की आर्थिक दशा, भीड़ भाड़ युक्त परिवार, मानसिक अयोग्यता और भावात्मक स्थिति आदि। परंतु यह देखने योग्य है, इस सभी में किसी का संबंध बालक के व्यक्तिगत विचार से नहीं है, और इसके रोकथाम के लिए जो उपाय बताए गए हैं उसमें है पारिवारिक स्नेह, समुचित शिक्षा, पुनर्वास, सुधार गृह। उन्होंने कहीं भी बालक अपराध की तुलना वयस्क अपराध से कर देने की बात नहीं कही गई है। मान्यवर, सामान्य रूप से हम देखें तो बालक में वयस्क की तुलना में कितनी भावनाएं शीघ्र प्रकट हो जाती हैं, यह बड़ा आसान होता है। इसमें उसका कोई व्यक्तिगत लाभ या हानि हो उसे फर्क ही नहीं पड़ता। उदाहरण के लिए हम पिछले आंकड़ों को देखें, कुछ 70% हमले में नाबालिग बालकों का उपयोग किया गया। उनके रोकथाम के बजाय हम उनकी तुलना वयस्क पुरुष से कर दें, क्या यह न्यायोचित है? अगर उदाहरण के रूप में देखें तो कश्मीर में ऐसे तमाम घटनाएं हुई जहां बहके हुए बालकों को सुधार किया गया और आज वे राष्ट्र निर्माण में अपनी भूमिका निभा रहे हैं। मान्यवर, जब सरकारें नाबालिग के वाहन चलाने पर 25,000 का चालान उनके माता पिता से करती है, तो फिर मान्यवर उसी बालक के बंदूक चलाने पर उनके माता पिता के ऊपर कार्रवाई की अपेक्षा बच्चे के ऊपर लांछन क्यों लगाया जाता है? क्या इससे उसके मानसिक स्थिति पर कोई प्रभाव नहीं पड़ेगा? इसके आगामी जीवन में कितनी क्षति होगी, इसका किसी ने सोच भी किया? आगामी जीवन में उसे किस नजर से देखा जाएगा, इसका विचार किए बिना भावात्मक सरिता में बह जाना क्या न्यायोचित है? अगर मैं संवैधानिक पक्ष की बात करूं तो जिस समता समानता की बदौलत हमारा देश आज तक बिना किसी आक्षेप के, बिना किसी समस्या के निरंतर प्रगति पर है, आज उस पर उंगली उठाना दिमाग का दिवालियापन नहीं तो क्या है? अपराधी को दोषी ठहराना अपराधी न्याय प्रणाली का एक महत्वपूर्ण सिद्धांत है, परंतु श्रीमान बच्चों के लिए आपराधिक शब्द का प्रयोग कर लेना विधि सम्मत है? शेर सिंह बनाम यूनियन ऑफ इंडिया केस 2016 में स्पष्ट रूप से देखा गया था कि बालक को कैसे एक सामाजिक विकार ने बहला फुसलाकर आपराधिक कृत्य कराया, और बाद में खुलासा हुआ कि जिसके साथ आपराधिक कृत्य हुआ था वास्तव में उसके साथ बालक का कोई संबंध ही नहीं था। श्रीमान, अधिकार संरक्षण और भारतीय संविधान की अनुच्छेद 39(च) में तथा वैज्ञानिक दृष्टिकोण से भी यह स्पष्ट रूप से देखा गया है कि बालक के स्वस्थ विकास के लिए अवसर उपलब्ध करवाना तथा स्वच्छ स्वतंत्रता वातावरण उपलब्ध होना उसका अधिकार है और यह आवश्यक भी है। तो उन्हें वयस्क के समान तुलना करके उन्हें मानसिक रूप से प्रताड़ित करना उनके अधिकारों का हनन नहीं तो क्या है? श्रीमान, जिस बालक को बचपन में हथकड़ी पहना दी जाए उसे आगामी समय में राष्ट्र की प्रगति की उपेक्षा की जाए, दूर दूर तक इसका कोई संबंध नहीं। अरे संबंध तो छोड़िए, उसे एक जिम्मेदार सशक्त नागरिक बनने की भी उपेक्षा नहीं की जा सकती, क्योंकि उसके मानसिक विकास की उपेक्षा जेल में करना दिमाग का दिवालियापन है। मुझे तो लगता है हमारे विपक्षी बंधु सत्यजीत राय की वो जो फिल्म है उसे देखकर आए हैं, जहां एक बच्चा जेल में जाता है, पढ़ाई लिखाई करता है और बाहर आता है तो अपने ही गांव में वो थानाध्यक्ष बन जाता है। समाज को इस अहितकर स्थिति से बचाने के लिए, इसके रोकथाम के लिए मनोवैज्ञानिक की सहायता से अभिभावकों तथा अध्यापकों को यह ध्यान देना होगा कि बच्चों के आपराधिक आचरण की कारण
शशांक, your time is up.
Okay, now judges, you can ask the questions.
हेलो
जी सर।
शशांक, ये बताइए कि बच्चे का सर्वोत्तम हित से आप क्या समझते हैं?
सॉरी सर, स्पष्ट नहीं हो पा रहा, एक बार और।
बच्चे का सर्वोत्तम हित शब्द से आप क्या समझते हैं? बेस्ट
सर
इंटरेस्ट ऑफ द चाइल्ड।
यस सर सर बच्चों के सर्वोत्तम हित से अभिप्राय हमें उस वाक्य से है जहां पे एक बच्चे के सर्वांगीण विकास की बात की जाती है। सर्वहित अर्थात हर प्रकार से उसका हित कैसे हो, वो सामाजिक, आर्थिक, राजनीतिक हो सकता है। सर्वहित उस टर्म से जुड़ा हुआ है सर जहां एक बच्चा स्वतंत्र रूप से अवसर और अन्य स्वतंत्रता प्राप्त करता है, वह समाज में अपनी पृथक रूप से भूमिका निभाता है।
कोई विधिक उदाहरण, कोई विधिक प्रोविजन जो आप बताना चाहें कि ये है सर्वोत्तम हित के बारे में?
सर भारतीय संविधान के अनुच्छेद 39 में ये कहा गया है कि हर बच्चे को उसके सर्वांगीण विकास के लिए अवसर की क्षमता समान रूप से दी जानी चाहिए। उसे हर प्रकार से सुविधाएं उपलब्ध करानी चाहिए। ये उसका अधिकार है जिससे वह अपना हर प्रकार से विकास कर सके।
और किशोर न्याय अधिनियम 2015 जो है, क्या उसमें कुछ है ऐसा बच्चों के सर्वोत्तम हित के लिए?
सॉरी सर, इसके विषय में नहीं जानता।
कोई बात नहीं। किशोर कौन है ये तो पता है ना आपको?
जी सर।
किशोर किसे कहते हैं? किशोर किसे कहते हैं?
जी सर।
कहाँ लिखा है?
जी सर।
कहाँ लिखा है किशोर किसे कहते हैं?
सर जैसा कि मैंने पढ़ा था जुडिशियल जुबाइल एक्ट 2015 में सर, वो बालक जिसने अभी अपनी 16 वर्ष की उम्र पूरी की हो या पूरी करने वाली हो, उसे किशोर कहते हैं। मतलब 16 वर्ष के जो ऊपर के हैं उन्हें किशोर कहेंगे।
जुवेनाइल, मेरे किशोर का मतलब था जुवेनाइल।
जी सर।
जुवेनाइल 18 के अंदर वाले को जुवेनाइल कहते हैं, ठीक है
सर? ठीक,
कोई बात नहीं। ओके
थैंक यू सर।
विनय सर एंड अरुण सर, आप लोग को कोई क्वेश्चंस पूछना है शशांक से?
No, it's fine.
ओके।
ओके शशांक, सॉरी मैं पहले नहीं पूछ पाया था तुमसे। शशांक, तुम्हें जुवेनाइल जस्टिस एक्ट में सीरियस ऑफेंसेस और हीनियस ऑफेंसेस में डिफरेंस पता है?
सॉरी सर, सीरियस ऑफेंसेस एंड
हीनियस ऑफेंसेस जो जुवेनाइल जस्टिस एक्ट में दिए गए हैं।
जी सर। सीरियस ऑफेंसेस सर, जैसा कि मैंने पढ़ा था, बहुत ज्यादा तो नहीं उसके बारे में पढ़ पाया, बट सीरियस ऑफेंसेस ऐसे थे सर जिनके वयस्क आपराधिक कैटेगरी में रखा जा सकता है। यानी जो ऐसे ऑफेंसेस जैसे हत्या, बलात्कार जैसी घटना है जो घनिष्ठ आपराधिक हैं, जिनको जो है वयस्क अपराध के समान ट्रीट किया जा सकता है। एंड हीनियस ऑफेंसेस सर जहाँ पे एक जो अपराधी है उसको सामान्य दंड, या ये कह सकते हैं कि सामान्य रूप से, जैसे कि 7 साल की सजा या फिर 3 से 3 कैटेगरीज बनाई गई थी, जहां तक मैं रिकॉल कर पा रहा हूँ, और उन्हें सामान्य रूप से या फिर बाल सुधार गृह भेज करके सुधारा जा सकता है, जहां तक सर मुझे ध्यान आ रहा है।
शशांक, सीरियस ऑफेंसेस और हीनियस में से सिवियर कौन सा वाला है?
मतलब कौन सा ज्यादा घनिष्ठ है ना, जघन्य के
जी
सर?
जी।
मतलब सीरियस ऑफेंसेस को सर ज्यादा लिया जा सकता है।
नहीं, हीनियस ऑफेंसेस हैं वो।
सॉरी सर,
यही तो आपने डिफरेंस में गलती करी।
अच्छा जी।
दूसरा क्वेश्चन मेरा आपसे ये है कि आपने कहा है अपने स्टेटमेंट में कि
जी
किसी बालक को अगर आप हथकड़ी लगा दे रहे हैं, सब कुछ आपकी बातें सही हैं, लेकिन क्या वो बालक है? अगर एक 16 साल का लड़का हीनियस ऑफेंसेस कर रहा है, मतलब रेप, मर्डर जैसे ऑफेंसेस में पार्ट ले रहा है, और उसका वो पहली बार, तीसरी बार, चौथी बार है, तो क्या आप उसको सेम तरीके से ट्रीट करेंगे जैसे आप दूसरे बालकों को कर रहे हैं?
सर जैसे कि आपने बताया कि वो दूसरी या तीसरी बार है, तो पहली बात तो सर कि उसे पहली बार में ही उसको उचित करना जाना चाहिए, जैसे बाल सुधार गृह आदि उसके ऊपर लगाए जाने चाहिए थे। लेकिन उसके बाद भी वो बार बार वही घटनाएं कर रहा है, तो सर इसके लिए प्रावधान होना चाहिए, वास्तव में प्रावधान होना चाहिए जिससे घटनाएं रोकी जा सकें। और रही बात सर हीनियस ऑफेंसेस, जैसा कि आपने बताया कि जो अति जघन्य अपराध हैं, बलात्कार या हत्या की घटनाएं हैं, तो सर जैसे अभी मैंने मेंशन किया था एक केस सर की शेर सिंह बनाम यूनियन ऑफ इंडिया सर 2016 का केस है सुप्रीम कोर्ट का। उसमें सर स्पष्ट रूप से देखा गया था कि बालक को बहकावे में आकर के घटनाएं कराई गई थी, बलात्कार की घटना थी पहला। और दूसरा सर हम देखते हैं कि समय समय पर आतंकवादी घटनाएं होती हैं, उसमें ज्यादातर सर अवयस्क बालकों का ही उपयोग किया जाता है। लेकिन सर 90% ऐसे केसों में, या ये हम कह सकते हैं उससे अधिक ऐसे केसों में होता है कि वैसे बालकों को समझा बुझाकर या फिर बाल सुधार गृह में भेज करके उनका निवारण किया गया है। तो सर हम ये बिल्कुल नहीं कह सकते कि 2-3 बार की जिसकी घटनाएं उसने की हुई हैं या फिर कोई जघन्य अपराध किया हुआ है तो उसको दोबारा से फिर हम समाज के लिए उचित नहीं कर सकते।
आप कह रहे हैं कि बच्चे को बहका के, तो क्या आपको लगता है विशाखा केस में तो जुवेनाइल था, क्या उसे बहकाया गया होगा?
सर मैंने कहा कि 90% केसों में 10%।
देखिए 10% के लिए तो एक्ट बना ही है।
जी सर।
90% के लिए तो एक्ट बना ही है।
जी जी
समझ रहे हैं, 90% लोगों के लिए तो एक्ट बना ही है। हर
जी सर।
किसी लड़के को, अगर किसी ने पहली बार ऑफेंस किया है, उससे गलती से हो गया, उसके लिए तो एक्ट बना ही है। पर यहाँ पे जो टाइटल दिया गया है वो हीनियस ऑफेंसेस के लिए ही दिया गया है,
जी
वो
जी
सीरियस और पिटी ऑफेंसेस के लिए नहीं दिया गया है।
जी
हम
सर।
सीरियस और पिटी ऑफेंसेस की बात ही नहीं कर रहे हैं,
जी
हम
सर।
सिर्फ हीनियस ऑफेंसेस की बात कर रहे हैं। तो ऐसा क्यों है कि आप कह रहे हैं कि हीनियस ऑफेंसेस के लिए नहीं देना चाहिए?
सर जघन्य अपराध की पीछे की मानसिकता, जिसे मैंने जैसे आपने कुछ दिन पहले हमें क्लास में बताया था, उसके पीछे की मानसिकता उसकी क्या थी। जैसे कि मैंने पढ़ा था सर कि बलात्कार की घटना ना तो किसी शिक्षा में सिखाई जाती है, ना किसी माता पिता द्वारा अपने बच्चों को सौंपी जाती है। वो अपने हार्मोन्स के वृद्धि के अनुसार वो कृत्य करता है। तो सर उसकी
तो
पूर्ण रूप
आप ऐसा मान रहे हैं ना कि उसके हार्मोन्स इतने बढ़ गए हैं कि हाँ वो उस तरीके से चीजों को समझ पा रहा है, उसको पता है कि क्या वो कर रहा है वो गलत है कि नहीं है, गलत की श्रेणी में आ रहा है कि नहीं है। जब उसका इंटेंशन ऐसा हो गया है तो उसे अडल्ट की तरह क्यों ना ट्रीट करें?
सर जे जैसे अभी एमजे स्टेलिन की किताब है सर सोसाइटी एंड क्रिमिनल में, उसमें स्पष्ट रूप से कहा गया है कि कोई भी बालक सर बचपन से ही अपराध नहीं होता। समाज की परिस्थितियां, पारिवारिक स्थिति, माता पिता के या फिर आसपास के आचरण को देख के वो सीखता है। तो हम ये सर उसके ऊपर नहीं थोप सकते कि ये तुम्हारी ही गलती थी और हम इसके लिए तुम्हें दंडित करेंगे। हर प्रकार
देखिए
के बाल।
यहाँ पे एज लिमिट है। अगर वो लड़का 18 साल 1 दिन का है और
जी
17 साल 11 महीना 29 दिन का है,
जी
तो क्या वो 2 दिन से क्या वो बालक बालक नहीं रहेगा?
जी
और जो आप परिस्थिति कह रहे हैं, जो आप समाज कह रहे हैं, वो तो सबके लिए है ना।
जी सर। सर
चाहे वो 18 साल के ऊपर अपराधी है, चाहे 18 साल से नीचे अपराधी है।
जी जी
भाई एक चोर चोरी तभी करेगा जब उसके पास पैसे की दिक्कत है।
जी सर।
तो चोरी ही करना थोड़ी ना एक उपाय है।
जी सर, पहली बात तो बलात्कार करना या हत्या करना किसी की आवश्यकता नहीं हो सकती। वो मानसिक विकृति कह सकते हैं या मानसिकता में परिवर्तन कह सकते हैं या फिर बहकावा हो सकता है। बाकी सर रही बात कि अगर उसने कोई जघन्य अपराध किया है तो उसके साथ कैसा ट्रीट किया जाना चाहिए। सर उसके मेरे मत के अनुसार या फिर कहें कि मेरे निष्कर्ष के अनुसार मेरा व्यक्तिगत ऐसा होना चाहिए कि पहले उसकी जांच होनी चाहिए, निष्पक्ष जांच होनी चाहिए, बच्चे की मानसिकता देखी जानी चाहिए, मानसिकता की तुलना की जानी चाहिए, स्थिति की तुलना की जानी चाहिए, उसके बाद उसके ऊपर न्यायोचित कार्रवाई की जानी चाहिए। जैसे कि निर्भया केस हमने देखा था पिछली साल, सॉरी 2015 का निर्भया केस जब हम देखते हैं तो वहां पे बच्चे की मानसिकता रही नहीं रही, वो बहकावे में आ गया। कुछ लोग जो थे उसके साथ वो वयस्क थे। ये आवश्यक, क्या ये आवश्यक नहीं कि उन्होंने उसे बहकाया हो? या फिर अगर सर हम 4 लोग रूम पे रह रहे हैं तो
आप ऐसा कह रहे हैं कि आपने चार्जशीट पढ़ी है, आपने देखा है, आपको लगता है कि जजेस ने कोई गलती करी होगी वहां पे, किसको बहकाया गया होगा? आप
सर
उस केस में बात करें जो केस ऑलरेडी डिसाइड हो चुका है।
जी सर, जी सर। सर
आपको
मैंने
समझना है कि आप ऐसे केस में बात करेंगे जो डिसाइड नहीं हुआ था, जो फिर ऑलरेडी जजेस ने डिसाइड कर दिया, वो गलत कैसे डिसाइड कर सकते हैं?
नहीं सर, मैंने
आप
एक
तो उस
उदाहरण,
लड़के का पक्ष ले।
नहीं जी सर, मैंने एक उदाहरण प्रस्तुत किया कि ऐसा हो सकता था।
चलिए ठीक है।
जी सर, धन्यवाद सर, प्रणाम।
विवेक सर।
सर
ठीक है सर, ये बहुत बढ़िया था। रिजल्ट कब तक देना है?
सर रिजल्ट 5 PM तक देना है सर।
Thank you.
Thank you, judges.
To have the opportunity to address such a talented gathering of hard-working students. I would also like to thank our esteemed judges for giving their valuable time to this competition. And now, at last, I would also like to thank Team Lawlicious for organizing such a wonderful competition and proceeding it with such an ease and confidence. Now, at last, I would like to inform everyone that we have the preliminary round and then final round, and from the final round we have concluded three winners, that is first, second, and third. So now it's time to announce our winners. So on first we have Maria Firdausia with team code 03. On the second number, we have Monica Kainat with team code 10, and on the third, we have Mehak with team code 16. Congrats to all the participants. You have done really well, and all the other participants, you also have done so much well. And at last, I would like to inform all the winners that you will be provided with a number of our founder of Lawlicious. You can contact with him for your prices. And at last, I would also like to request all the participants to join our Lawlicious links on Instagram, WhatsApp, YouTube for more such events and debates and other competitions which will help you in new learnings and for your future. More thing I forget to mention that our winners, that is Maria Firdausia, she is from Integral University Lucknow. Monica Khainat, she is from City Law College Jankipuram Lucknow, and Mehak, she is from BHU Varanasi.
नमस्कार। जैसा कि आप सभी लोगों ने इस डिबेट में पार्टिसिपेट किया और बहुत ही एक अच्छे उत्साह के साथ अपना पूरा मेहनत करके डिबेट में प्रीलिमिनरी राउंड के साथ फाइनल तक पहुंचे हैं, और जो कुछ 1 या 2 मार्क्स की वजह से फाइनल से बाहर हुए हैं या प्रीलिमिनरी से बाहर हुए हैं, उसका ये मतलब नहीं है कि आप यहीं से हार मान लें और नेक्स्ट डिबेट कॉम्पिटिशन या किसी कॉम्पिटिशन में पार्टिसिपेट ना करें। अतः हम आपसे यही आग्रह करना चाहेंगे कि आप बहुत अच्छा आगे कर सकते हैं। कोई ना कोई एक्सपीरियंस जो आपको इस कॉम्पिटिशन से मिला होगा, वो आपने जो यहाँ पर आपके जो लूप होल्स हैं, वो हम लोग अभी प्रोवाइड कर देंगे, वीडियोस भी वहाँ देख सकते हैं, और अपने उन्हीं लूप होल्स को फिल करते हुए आप नेक्स्ट कॉम्पिटिशन में पार्टिसिपेट कर सकते हैं। और ऐसा नहीं है कि आप लॉ स्टूडेंट हैं। हमने देखा कि बहुत सारे बच्चे ऐसे कर रहे थे कि वो लीगल डिबेट को एक साहित्यिक डिबेट बना रहे थे। लीगल टर्म्स को यूज ना करके वो अपनी लाइक पॉलिटिशियंस की तरह स्पीच दे रहे थे। तो ये पॉलिटिशियंस की तरह स्पीच देना ये लीगल डिबेट में हमें तो नहीं सही लगता है। बाकी आप लोग जो भी सही समझें। और आपको एक लीगल डिबेट इसीलिए हम लोगों ने टॉपिक रखा था लॉ से रिलेटेड। अगर आप किसी चीज के बारे में सर्च कर रहे हैं, कोई भी टॉपिक पर बोल रहे हैं, तो एटलीस्ट आपको उस टॉपिक के जो बेसिक हैं, बेसिक डेफिनेशंस हैं, वो याद होना चाहिए। जैसे कि हमने देखा बहुत सारे पार्टिसिपेंट्स को जुवेनाइल की डेफिनेशन नहीं याद है, जुवेनाइल किस सेक्शन में डिफाइन है ये नहीं याद है। हाँ, मैं मानता हूँ आपके बोलने की शैली बहुत ही अच्छी है, परिभाषा आप बहुत अच्छे से दे लेते हैं। आप हिंदी में वक्ता अच्छे हैं, स्पीकर अच्छे हैं, इंग्लिश में हर जगह आपका कंटेंट मैटर रखता है। अगर आप लीगल डिबेट में आए हैं तो आपको अपने लॉ के टर्म्स रखना होगा। फिर भी उसने लीगल टर्म्स को यूज किया और वो फाइनल में बस 1 नंबर से रह गया फाइनल में आने से प्रिलिमिनरी में। और उसने 2-3 मिस्टेक ये की थी कि लाइक उसने जो जजेस थे वहां पर जजेस बार बार उसको कॉल कर रहे थे कि रुकिए रुकिए, वो अपने आप में फिर स्टार्ट हो वहां पर उनका वही लूप होल्स रहा, इसीलिए वो फाइनल्स में नहीं आ पाए हैं। बाकी उसने बहुत ही अच्छा बोला था। और आप लोग मेहनत करते रहिए, लॉलिशियस से ऐड हो, और आप नेक्स्ट इवेंट भी हम लोग करवाते रहेंगे, उससे पार्टिसिपेट करते रहिए। बाकी शैली जी आपको आगे बताएंगी। धन्यवाद।
Thank you, Vivek. And at last, I would like to thank all the participants for their wonderful cooperation. And I would also like to inform that you all have done extremely well. Only with 1 or 2 points you were left. So I would wish you all the very best for your futures. And would also like to inform you that For the next time, be prepared with some good points. And at last, I would also like to request you all to please go through the links which is provided in the Ace of Debate competition group or all the other groups which you were added in for upcoming events which will provide you benefits for your future. Thank you.
और एक चीज और, मैं टीम लॉलिशियस की जो ऑर्गेनाइजिंग मेंबर्स हैं उन्हें भी बहुत बहुत धन्यवाद देना चाहूंगा जो इस कार्यक्रम को सफल बनाने में कहीं ना कहीं उन लोगों का बहुत बड़ा योगदान रहा। शैली, नाजरीन, अंशिका, मेहरान, दिव्यांशी पाल, अंजलि त्रिपाठी, मानसी दंगल, आकृति पटेल, आप सभी लोगों ने एक बहुत ही ज्यादा मेहनत करके लाइव हम लोगों ने रात में भी मीटिंग रखी है, दिन में भी मीटिंग रखी, किसी भी टाइम पर अगर लॉलिशियस के रिगार्डिंग मीटिंग रखना है तो आप लोगों ने उस टाइम पर भी सपोर्ट किया और कॉपरेशन दिया, इसके लिए बहुत बहुत धन्यवाद।
Thank you, Vivek, from the rest of the team members of Lawlicious.
Thank you everyone, and now you can leave the meeting.